watching Property TV.
Hello and welcome to Property Question Time. I'm Stephen Galpin, and today we've got a little bit of a different format. We've got a special programme that's concentrating on the world of commercial property rentals, in particular the difficulties that have arisen through the coronavirus period and has resulted in new legislation by the government. And joining me today to discuss these matters is Byron Crellin, CEO of Clearway Debt Squared, who are property asset managers, I think that's probably the best way of putting it, and Francis Coulson, who's a partner at Wedbell Solicitors. Welcome to you both.
Thank you.
I think, Francis, if I could ask you, there have been certain things that the government have done to freeze, to give some comfort to tenants who've got into financial difficulties during the period of the pandemic. I wonder if we could start off by looking at what the situation was at the beginning of the pandemic and what the initial help from the government sort of was, and then if we can we'll move on to what the new legislation has got to say.
Yes, well, obviously it came as a massive shock to everybody in March 2020 and nobody knew what was going to happen, and I think the government reacted very well actually to providing business support. So suspension of business rates, furlough monies, and all the protections against enforcement, debt recovery, winding up petitions, statutory demands and so forth. So actually I think that was a very good reaction from government, and the bounce back loans, CBILS, etc. So I think that has had the desired effect. I think it has rescued an awful lot of businesses and saved an awful lot of jobs. And this has been obviously a long period, a couple of years now. So I think that worked really well.
Okay, now those initial offers of help that came in at the beginning of the pandemic, or the perception of the difficulties at the beginning of the pandemic, you had to have had your problems caused by the pandemic rather than perhaps had a problem before. It doesn't sort of roll into the same period, does it?
It doesn't, but I think there is those scenarios where you've got businesses, small businesses, that were unknowingly trading insolvent or in financial difficulties, that were just making do, and then were just snowballed into this pandemic. And I think what's coming through the wash and what we've seen since the regulations have come back March 2022 is a lot of new faces in properties where we weren't expecting to meet them, i.e. going to a property to say, you know, we're here to now resolve a situation. We're going, you're not the person that we're expecting to see.
Right, okay. Well, I think there have been a lot of, shall we politely say, anomalies caused by the assistance.
Yeah.
I mean, we've had all the scandals of the bounce back loans that were given to companies that were formulated just for that purpose and all that sort of thing. We'll discuss that later. But going back to the very beginning, taking the situation of outstanding rents at that point in time, what was the first step taken by the government? Was it to freeze those debts? How did it work?
Yeah, so we had a protected period introduced, 21st of March 2020. We had then a ring fence of protection for tenants, so non-payment of rent, etc. And that basically froze the landlord and the landlord's agents from taking any course of action. So tenants were then protected for that period, and there is this ring fence period has different dynamics. So Wales, we're still in a protected period where we can't take possession on properties. That finishes in September 2022. Hospitality is a different date to if you're a business such as an office, you've got no protection. Hospitality was completely protected. So it is slightly murky in the sense that you've got this protected period.
Listen, I'm a little bit London-centric, so let's leave Wales out of it for the moment. What I'm trying to get to, Byron, is that at that point that the government said, yes, we're going to ring fence these debts that are building up. How did that work against the ongoing rents that were being incurred?
Well, we had back rent, so the government introduced and said, and we went through a continued update of the legislation in terms of what you can enforce pre-pandemic in terms of rent. And where we got to was 554 days of rent due,
Right.
where you could use an enforcement agent to collect rent. You were able to forfeit leases for non-fiscal breaches. So if somebody had done a misdemeanor in terms of outside of their lease, and
That still stood.
and that, yeah. So we had pre-arrears pandemic, where as long as you had 554 days of rent due, then you could pursue the tenant. A lot of tenants were aware of this caveat and got themselves under the radar of 554 days. So the landlords were just basically, I want to say handcuffed. That sounds probably slightly harsh, but landlords were handcuffed from taking
You're sitting
anything.
next to a solicitor here. I don't know whether she's going to approve of the methodology there.
Well, we have to. We'll be balanced, and Francis is right. The government did the right thing to protect businesses. You know, we needed to make sure that the high street came back out of this. You know, and doors open and lights went back on. And there are geographical areas now that are just hemorrhaging as a result of the pandemic that were suffering before that as well. So the government did the right thing, but I think landlords now, you know, are needing to get back to business. There's a huge push on landlord-tenant relationship and negotiations that are taking place.
Okay. Francis, at the beginning of this ring fencing and the initial steps taken by government, how was the government's communication? Was it easy to understand, or were you inundated as a firm of solicitors answering questions?
Again, I think it was fairly well communicated. I think there was a range of reactions from landlords because, again, going back to March 2020, nobody knew what was going to happen. It was very, very much the unknown. And if you were affected by the virus, but not shut down, not mandated to shut down, again, there was concern about how your finances were going to go and so forth. And some landlords were very good at discussing things with tenants and being quite open to a sensible discussion, and other landlords were fairly aggressive about enforcement. And there's a middle way, you know, let's look at your figures, let's talk about how it's actually affecting you, and let's see how that goes. So I think there was a range of responses from landlords.
Okay. I mean, I've done programmes before with Byron, and I think we've all been agreed in the past that the sort of interaction between tenant and landlord has definitely got better over these last 2 years. Because it's just been...
It's had to.
It's had to, hasn't it? Yeah, absolutely so. Okay, well, before we start talking about specific questions that we've had in on this subject, let's move on now to this year and the new legislation that's come in to, I suppose, effectively replace this ring fencing. Okay.
So ring fence is kept. So we've still got this protection period. Rent is back on. So the protected period remains in place. So that's the landlord-tenant negotiations, arbitration processes are all available in accordance with the new legislation that they came through. But March 2022 saw the handcuffs come off in terms of being able to, for future rent for the March quarter that's quarterly demanded in advance. We've seen a flurry of activity. We've seen a lot of activity on repossession.
Okay.
And I'm just wondering whether that is partly because landlords are also, through due diligence, aware that ownership of businesses have changed hands, etc. But yeah, we're now seeing a back to business normality in terms of activity.
Well, Byron, that's all very nice to say. You see a lot of activity in terms of repossession and enforcement. How are the courts dealing with this? Because I mean, I'm a magistrate. I only deal with criminal matters, not commercial matters. But I mean, I know the waiting list. I mean, you'd be lucky to get a hearing inside of 12 months at the moment in the criminal courts.
Well, we're talking about a piece of legislation that is, Francis will correct me, you don't need a court order to take possession. So purely on commercial, a landlord can instruct an enforcement agent today to say, go and repossess Unit 1. And the only criteria that we follow is that it has to be peaceful, so nobody in occupation, and that's so landlords have been out the blocks quite quickly on that, for a number of reasons, of course, but getting their portfolios back into shape. And Francis mentioned about sort of how certain different landlords have taken different attitudes.
But possession doesn't get you the money, does it?
No, and I think that's where a landlord is making a calculated commercial decision based on, am I likely to get? We don't know what the history was between that landlord and tenant, and they might be looking at saying, we've got limited opportunity to recover this. We may have a new tenant lined up, so we're going to mitigate our exposure even further. Now we've got the ability to take possession, cut it off, and move forward.
Okay, but if I understood you correctly, then, so the new legislation will relate to current rental situations, but the original ring-fenced amount will still stay there, perhaps with a payment plan or something put in place. Is that how it would work?
Yeah, and down to a landlord and tenant to get into that payment plan. Yeah. If they can't, then you go into an arbitration, or either party have got the option to go into arbitration, or alternative. Is
that a fair summary?
Yes, I think you've got to think of the landlord-tenant relationship as having resumed, and then you take the protected period, say from March to July 2021, and that's sort of held separately in abeyance, and you can trigger the arbitration process to deal with that sort of held in abeyance piece of rent, which is a legacy problem from the pandemic. Okay. And so the government's introduced this scheme to try and tackle that, whether it's by giving relief to the tenant or saying, actually, no, you're not having any relief. So I think it's just trying to deal with that historic problem.
So Francis, you were relatively complimentary about the government's efforts at the beginning of this. Are you equally complimentary about the follow-on legislation?
I have my doubts about the arbitration scheme. I think there are lots of issues with it.
Is that doubts in arbitration or an arbitration scheme?
In the scheme, in this particular scheme. I have my doubts about it because there are so many variables, and I think there are inherent risks for both landlord and tenant in the process. That's not to say it won't work in some cases, perhaps with larger commercial organisations, but I think there are risks that both sides need to consider without, they can look at the process and say, well, that might work, but I think there are wider considerations both sides need to consider.
Sure. And just finally, in this half of the show, just a quick comment from you both. Are the arrears and the problems and the difficulties caused by the pandemic as big as we thought they might be?
I think by certain market sectors, it's like a bomb gone off. I think there are other market sectors that will come through this, so it just needs time to heal.
Okay.
Yeah, and that's partially what the ring fencing is about. Yes. You know, take the legacy period out, sort it out, and give people a chance to recover. Yes. Aside all the sort of other insolvency rescue things that you can use. But yeah, very variable from business to business, I think.
Good. Okay, well, thank you both very much for that. Join me again after the break when we'll be asking Francis and Byron some more specific questions about the new legislation.
You are watching Property TV. You are watching Property TV.
Hello, welcome back to part 2 of Property Question Time. I'm Stephen Galpin and I'm joined by Byron Crellin and Francis Coulson, and we're discussing the Commercial Rent Coronavirus Act 22 legislation. Yeah, I got it right, I think.
It's enough.
Okay, now we have some specific questions that have been sent in, and we'll start off, Byron, with one for you. I'm a senior credit controller, and throughout the pandemic, myself and my team have been working with tenants to agree stage payments on behalf of our landlords, of course. Can the panel confirm what our options are if, in fact, the tenants stop making payments under these arrangements?
So we're obviously talking about protected rent. So limited options in terms of availability. If you've entered into a payment plan, totally commendable, and that's great. If tenants are defaulted, the government's recommendation and continuously have repeated the message of communicate to each other, talk. So if somebody defaults on a payment plan, the government's expectations would be that you would just re-engage and get them going again. the default position is that if either party can't agree on a payment plan or have defaulted and are refusing, or for whatever reason are stating that they can't re-engage with the payments, then the alternative would be, which the government have introduced, is the arbitration process. There are alternatives to arbitration. The government's recommendation and guidelines are in accordance with the Act, is that if you can't agree, you go through arbitration. But I think what the key point as well is that arbitration it's not just available. You've almost got to qualify for arbitration. So from a tenant's point of view, you can't say, well, I'm more or less broke and I've got no money, so therefore I need time to pay. Well, actually, the arbitration will view that potentially that you're insolvent and you don't qualify for arbitration. In fact, you shouldn't be trading. So there's some hoops you've got to be clear to go through to consider arbitration. But if it's protected rent, then it's literally just negotiate. If you can't negotiate,
I think what you're saying is if the will is there on both sides, then it's going to work. I think that's about it.
Yeah, and I think we've seen that. We've seen that.
I mean, Francis, what's quite interesting, as I mentioned before we took the break, Byron and I have talked in the past about relationships between tenants and landlords. And of course, there is a third factor, and that's the solicitors. Now, I mean, if we go back in time, and I'm sure you'll forgive me, but I mean, there was a sort of...
You're not going to suggest ambulance chasing.
No, there has, but there has been a practice in the past to say, yeah, we'll have a chat. And that chat involves issuing a writ on a Friday night at 5 o'clock and giving the recipient a bad weekend, and that used to be a sort of quite famous litigator sort of practice. But have you found, as a solicitor with a leading firm, that the relationship between solicitor and tenant and landlord has changed over this period?
Not just over this period. I mean, litigation has evolved, and the courts frown very much on that sort of Friday night writ with no warning. It's not even called a writ anymore. It's terrible. So I think that has evolved of itself.
Yes.
And during the period, certainly, as Byron says, the government's been expecting communication between landlord and tenant. You would not be serving your landlord or tenant client if you just take a completely legalistic view of everything and that's all the advice you give. You have to be a commercial partner with your client in whatever business they're in, and try and look at what they're trying to achieve, what their personal situation is, their business, and then try and work out the best way to get to the right result for them.
Do you know, I really like that expression, instead of a client, they're a commercial partner. I like that. I think that's very descriptive and very good, actually. And it's constructive, isn't it?
That's what a modern lawyer should be,
Yeah, great. Okay, Francis, your question. Our business manages multiple tenants across the UK. Can the panel explain what the protected period is and why it is different for different businesses, i.e. business sectors?
Yeah. Well, as we were discussing in part one, the protected period is the ring-fenced period, so the period during which the pandemic affected businesses mandatorily, so if they were shut down or restricted. So that's very different for different businesses. So if you're a landlord that has is housing a number of different sectors, so hospitality, all sorts of things, they will all be very different. So as Byron said, offices were not shut, although clearly they were, people were really restricted practically, so there were practical issues. If you were a pharmacy or a post office, you were not shut down because people needed you, or a supermarket, you weren't shut down. But many businesses were shut down, so you'll have to look at, you could look at it sector by sector and try and work out sort of algorithms, but really it's quite a task for a large commercial landlord to look at all of their individual tenants, because you have got to look at it business by business.
Yes. But I suppose you could say it was targeted the best one reasonably could, I suppose.
Absolutely,
That's the way. Okay, great. Byron, as a property owner, can the panel confirm how long is the government's moratorium period is going to run for, or is there no particular end date at the moment?
Well, they've said 6 months, but I don't think they put a full stop next to it. So we're expecting 6 months.
From when?
So March 2020.
Yeah.
And
but that ran till then the September, didn't it? I think, from memory. Yeah. Okay.
And then we go again, and then I think the issue that we've got is what the government are doing is they're leaving the door open to say, right, okay, we're going to have this. So if you're not in arbitration, and you've got this 6-month window to negotiate this protected period of arrears. I think the government are going to take a view on what's been resolved within this 6-month window, and I mean, we don't know, it's crystal ball time, but month 4, month 5 of this, it could be that they introduce further new legislation to extend it again. We've got restrictions in Wales that continue. So we mentioned in part 1 that you can't take possession in Wales until post-September. So you've got that. So I think it's a watching brief. The answer is 6 months. If you're into arbitration, until arbitration is completed, you're protected because you're in that process.
Okay. So is there any incentive within that 6-month sector not to start arbitration?
Well, there are all sorts of reasons why you might not choose the arbitration.
Yeah.
So, for example, Byron was talking about the qualifying factors before. So, apart from being a business tenancy, the arbitrator has got to go through checking that you're a business tenancy, so you're eligible, checking that the tenant's business is viable or would be made viable by being given relief without affecting the landlord's solvency. So, if your a business is not viable, effectively you need to go and look at another insolvency process, because as a director of a non-viable business, you will be exposing yourself to personal liability if you don't take proper advice at that stage. So I think that you have got to look at each case individually.
I think also landlords will look at this and say the government arbitration process is something that they can't control the outcome of, because you've got an independent arbitrator that's going to basically make a decision based on the information that's presented. So from a tenant and from a landlord, our recommendations, I'm sure Francis will agree, is that if you are on either side of the table and you're in arbitration, you literally need to give war and peace in terms of your position, so the arbitrator can make a calculated commercial decision that's fair and based. However, the landlords are aware, and we've spoken to a number of clients following throughout the pandemic, and once we had clarity in terms of what the Act actually stated and coming out of March 2022, a lot of managing agents, landlords are thinking arbitration is not for us because it's something that potentially we can't control the outcome of.
I think probably one of my fears is that if there's a sort of cliff edge put in place where you have assistance and then whoosh, it stops, because that's the point at which there will be bitterness, confusion, difficulties.
Well, I think that's what the government has said. They've said you've got 6 months to do it.
Yeah.
Get it resolved.
I mean, I think it's a little bit like Rishi Sunak, isn't it? A year ago everybody thought he was a hero because he was giving money away, and I kept saying in here, they laugh at me. I'd say, you wait till he tries and gets it back.
Yes, you're only as good as yesterday's cheque.
Yeah. Let's wait for the budget.
Yes.
And I just have this slight fear with this that I think the government help has been quite amazing in this respect. I think it's helped everybody. I think it's helped the legal profession. I think it's helped the professional sector. I think it's helped landlords and tenants communicate in a far, far better way and constructive way. I think the days of the sort of institutional landlords dictating that they only want blue chip tenants or else, they're over. There's all sorts of other considerations there, but I think this
different
is
landscape
one of the
now.
reasons.
New
Different
world.
landscape, totally. Okay, great. Francis, your last question. I'm an owner of a small number of retail shops, and we have had rent owing to our landlords. Can the panel explain the government's arbitration process and advise as to whether I should consider insolvency as an alternative option to that arbitration? So I suppose we've got somebody here who's just asking whether to go down a sort of formal path or whether arbitration would help.
Well, I think they've got to take advice on their particular situation. So we talked before about viability. They've got to look at their financial situation, see if they are likely to be able to convince an arbitrator that they are a viable business or could be made viable.
Can I just interject there? Sorry to break your head. So if I came to you in that position as a solicitor, would you send me back to my auditors and say, get some kind of schedule produced of your current financial position? Is that the way you'd approach it?
You certainly need to get all your financial data together. The guidance is envisaging looking at data from March 2019, so to show that you weren't just
Pre-training.
completely bust beforehand.
Yes,
And looking at management accounts, bank statements, leverage, all the various normal ratios that you would look at. So an insolvency practitioner could advise you about that. An insolvency lawyer could advise you about that. Your accountant can advise you about that. But you'll need to bring that data in any event to the arbitrator. So better to know what your position is before you trigger an arbitration, because you might then reduce your options by going to arbitration without having looked at that first.
Yeah. Well, that's all we've got time for. So I'm going to say a very big thank you to Francis Coulson from Wedbell. Thank you very much for coming in
Thank you,
today.
Stephen.
Byron Crellin, regular contributor to Property TV's programmes. Thank you very much for coming in
Stephen.
today. Thank you both for your wonderful advice and clarifications. So that's all we've got time for today. Join me again next time on Property Question Time.